Welcome to our new video. Today, we're going to talk about something really important in the world of business law: fast-track mergers under the Companies Act 2013. If you've ever wondered how smaller companies or holding subsidiary companies can merge without going through a long legal process, then this video is for you. So let's dive in and make it simple. Companies Act 1956 did not provide a simple procedure for mergers and amalgamations of certain type of companies. It prescribed a cumbersome and time-consuming process for all companies, irrespective of their size, net worth, and turnover. The legal provisions pertaining to merger process were stipulated in sections 391-394 of the Companies Act 1956. This procedure was perceived to be very confusing, complex, and time-taking by all stakeholders involved in the process. The process involved, inter alia, drafting a merger scheme, taking judicial approval for the scheme, getting board and shareholders' authorization, etc. It defeated the very purpose for which mergers were entered into, and proved to be a deterrent for companies looking for collaborations, rather than a facilitator. Small companies with fewer resources were also subject to same complex procedure. This was proving to be an obstacle in the way of their growth and expansion. Having the same procedure for merger for all companies was proving to be counterproductive. The complexities of the earlier regime gave rise to the need for a simplified procedure and a more efficient legal regime for merger process. This need was embedded in the following benefits, which a fast-track merger offered under Section 233 of the Companies Act 2013. Simplified procedure for merger. No judicial approval required. Separate procedures for certain type of companies would enable them to expand without any roadblocks. Form filings required also significantly reduced. No requirement to apply to the National Company Law Tribunal. No requirement to get a special audit conducted for the transfer company. No requirement to issue public advertisements announcing the merger. Less cost-intensive and less time-consuming. The Companies Act 2013 replaced the earlier tedious process with a new concept called the fast-track mergers. Fast-track mergers have dispensed with tribunal approval for mergers. However, it is to be noted that this process is applicable only to merger between small companies and holding and subsidiary companies. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Legal regime behind fast-track mergers: Section 233 of the Companies Act 2013, along with Rule 25 of the Companies, Compromises, Arrangements, and Amalgamations, Rules 2016, lay down the entire legal framework of fast-track mergers. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Notwithstanding the provisions of Section 230 and Section 232, a scheme of merger or amalgamation may be entered into between two or more small companies, or between a holding company and its wholly owned subsidiary company, or such other class or classes of companies as may be prescribed, subject to the following, namely: A notice of the proposed scheme inviting objections or suggestions, if any, from the registrar and official liquidators where registered office of the respective companies are situated, or persons affected by the scheme within 30 days is issued by the transferor company or companies and the transferee company. B. The objections and suggestions received are considered by the companies in their respective general meetings, and the scheme is approved by the respective members or class of members at a general meeting holding at least 90% of the total number of shares. C. Each of the companies involved in the merger files a declaration of solvency in the prescribed form with the registrar of the place where the registered office of the company is situated. D. The scheme is approved by majority representing 9/10 in value of the creditors or class of creditors of respective companies, indicated in a meeting convened by the company by giving a notice of 21 days along with the scheme to its creditors for the purpose or otherwise approved in writing. The transferee company shall file a copy of the scheme so approved in the manner as may be prescribed with the central government, registrar, and the official liquidator where the registered office of the company is situated. On the receipt of the scheme, if the registrar or the official liquidator has no objections or suggestions to the scheme, the central government shall register the same and issue a confirmation thereof to the companies. If the registrar or official liquidator has any objections or suggestions, he may communicate the same in writing to the central government within a period of 30 days, provided that if no such communication is made, it shall be presumed that he has no objection to the scheme. If the central government, after receiving the objections or suggestions, or for any reason is of the opinion that such a scheme is not in public interest or in the interest of the creditors, it may file an application before the tribunal within a period of 60 days of the receipt of the scheme under subsection 2, stating its objections and requesting that the tribunal may consider the scheme under section 232. On receipt of an application from the central government or from any person, if the tribunal, for reasons to be recorded in writing, is of the opinion that the scheme should be considered as per the procedure laid down in section 2 through 32, the tribunal may direct accordingly, or it may confirm the scheme by passing such order as it deems fit. Provided that if the central government does not have any objection to the scheme, or it does not file any application under this section before the tribunal, it shall be deemed that it has no objection to the scheme. A copy of the order under subsection 6, confirming the scheme, shall be communicated to the registrar having jurisdiction over the transferee company and the persons concerned, and the registrar shall register the scheme and issue a confirmation thereof to the companies, and such confirmation shall be communicated to the registrars where transfer company or companies were situated. The registration of the scheme under subsection 3 or subsection 7 shall be deemed to have the effect of dissolution of the transferor company without process of winding up. The registration of the scheme shall have the following effects, namely, transfer of property or liabilities of the transfer money to the transferee company, so that the property becomes the property of the transferee company, and the liabilities become the liabilities of the transferee company. The charges, if any, on the property of the transferor company shall be applicable and enforceable as if the charges were on the property of the transferee company. Legal proceedings by or against the transferor company pending before any court of law shall be continued by or against the transferee company. And where the scheme provides for purchase of shares held by the dissenting shareholders or settlement of debt due to dissenting creditors, such amount, to the extent it is unpaid, shall become the liability of the transferee company. A transferee company shall not, on merger or amalgamation, hold any shares in its own name or in the name of any trust, either on its behalf or on behalf of any of its subsidiary or associate company, and all such shares shall be canceled or extinguished on the merger or amalgamation. The transferee company shall file an application with the registrar along with the scheme registered, indicating the revised authorized capital and pay the prescribed fees due on revised capital. Provided that the fee, if any, paid by the transferor company on its authorized capital prior to its merger or amalgamation with the transferee company shall be set off against the fees payable by the transferee company on its authorized capital enhanced by the merger or amalgamation. The provisions of this section shall mutatis mutandis apply to a company or companies specified in subsection 1. In respect of a scheme of compromise or arrangement referred to in section 230, or division or transfer of a company referred to clause B of subsection 1 of section 232. The central government may provide for the merger or amalgamation of companies in such manner as may be prescribed. A company covered under this section may use the provisions of section 232 for the approval of any scheme for merger or amalgamation. Rule 25 of the Companies, Compromises, Arrangements, and Amalgamations Rules 2016. The notice in the Form CAA 9 of the proposed scheme to invite objections or suggestions from the registrar and official liquidator or persons affected by the scheme. The notice of the meeting to the members and creditors shall be accompanied by a statement disclosing the details of the compromise or arrangement, the declaration of solvency in Form Number CA.10, copy of the scheme. The declaration of solvency in the Form CAA-10 shall be filed by each of the companies along with the fee as provided in the company's registration offices and fees, Rules 2014, before convening the meeting of members and creditors for approval of the scheme. The transferee company shall, within 7 days after the conclusion of the meeting of members, or class of members or creditors or class of creditors, file a copy of the scheme as agreed to by the members and creditors, along with a report of the result of each of the meetings with the central government, along with the fees as provided under the company's registration offices and fees Rules 2014. Copy of the scheme shall also be filed, along with Form Num CAA 11 with the Registrar of Companies in Form Number GNL1, along with fees provided under the company's registration offices and fees Rules 2014, and the official liquidator through hand delivery or by registered post or speed post. Where no objection or suggestion is received to the scheme from the Registrar of Companies and official liquidator, or where the objection or suggestion of registrar and official liquidator is deemed to be not sustainable, and the central government is of the opinion that the scheme is in the public interest or in the interest of creditors, the central government shall issue a confirmation order in the Form CAA-12 of such scheme of merger or amalgamation. Where objections or suggestions are received from the Registrar of Companies or official liquidator, and the central government is of the opinion, whether on the basis of such objections or otherwise, that the scheme is not in the public interest or in the interest of creditors, it may file an application in the Form CAA.13 before the tribunal within 60 days of the receipt of the scheme stating its objections or opinion and requesting that tribunal may consider the scheme under Section 232 of the Act. The confirmation order of the scheme issued by the central government or tribunal under subsection 7 of Section 233 of the Act shall be filed in the Form INC 28 within 30 days of the receipt of the order of confirmation, along with the fees as provided under companies, registration offices and fees Rules 2014, with the Registrar of Companies having jurisdiction over the transferee and transferor companies respectively. For the purpose of this rule, it is clarified that with respect to schemes of arrangement or compromise falling within the purview of Section 233 of the Act, the concerned companies may, at their discretion, opt to undertake such schemes under Sections 230 to 232 of the Act, including where the condition prescribed in Clause D of subsection 1 of Section 233 of the Act has not been met. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Steps involved in fast-track mergers. The following steps need to be followed in a fast-track merger. 1. First of all, both the companies need to check their Articles of Association, AOA, and assess if they have the requisite authority under them to enter into a merger. If no, then the AOA need to be amended before such merger can take place. 2. Convene the board meeting and prepare a draft scheme of merger or amalgamation. 3. Prepare a financial statement of assets and liabilities and get an auditor's report prepared. 4. Get the draft scheme approved in the board meeting. 5. Both the companies need to send a notice to the Registrar of Companies and official liquidator, OL, of their respective regions inviting suggestions, objections to the scheme, if any, within 30 days of issuing the notice. 6. Such notice to the ROC should be in Form CAA-9 and have the following attachments: copy of the scheme, shareholding pattern of the transferee pre- and post-merger, last 3 years audited financial statements, memorandum and articles of association, board resolution, valuation report. 7. Both the companies are required to file a declaration of solvency with their respective ROCs. This declaration of solvency shall be accompanied by the following: board resolution, statement of assets and liabilities, auditor's report. 8. Sending notice of shareholders meeting and creditors meeting. 9. Conducting the shareholders meeting and getting the scheme approved. 10. Conducting creditors meeting and getting the scheme approved. 11. Filing of the results of each meeting with the regional director and the official liquidator by the transferee company. 12. Objections, suggestions to be sent to the regional director by the ROC official liquidator. 13. Regional director may file an application with the tribunal if he is of the opinion that the scheme is against public interest. 14. The tribunal can approve or disapprove the scheme. 15. If approved, it shall be filed with the ROC of the transferee company and the transferor company, respectively. The following consequences shall result out of the merger. The transferor company shall stand dissolved on the registration scheme. No winding up shall be required for the same. All the assets and liabilities of the transferor company shall be transferred to the transferee company. Any charge on the transferor's property shall stand transferred to the transferee. And that's it for today's video on fast-track mergers under the Companies Act 2013. We hope you learned something new and useful. Don't forget to like the video, share it with your fellow entrepreneurs, and subscribe to our channel for more such informative content. Hit the bell icon so you don't miss out on future uploads. See you in the next one.